and Jim Perdue were going to duke it out on the government code, which frankly is going to be the highlight of my week.
I know. I just asked a question. I'm not ready to duke it out, although Lisa is on the appellate one, so she's ready.
All right. All right, Jim. You're out.
I fear to say who I'm more afraid of. So I wasn't elegant, Justice Christopher. I would say that all I was trying to explain is that while we were navigating some language that had to do with remote proceedings in the Omnibus Court Bill 3774, I just think it's important when Chip tells the committee that he took a call from the chair of jurisprudence on the Senate, and I worked with the chair in the JCJ. If you look at the language of the government code regarding trial court shall sit in the county seat for jury trials, and it may sit elsewhere in the county for non-jury trials. I want to be real careful about this because I don't speak for the legislature, but on a policy discussion that we're having here, I unfortunately suffer the reality that politics touches everything, given the time with the legislature. And there is a political component that is worth at least putting on the record, that there are members of the legislature who view the language of the government code that says court shall sit as being a tool that provides for responsiveness and accountability for their judges to the community. And if you create a rule that substantively says those judges need not sit in their county to make determinations relevant to the citizens of their county, there's a political component to that. And that's all I was trying to point out. So I can read the government code, you can too. It says that. What does that mean when you say that there's remote access via Zoom? I don't know.
Okay, so I mean, but you were a little stronger than that earlier, and I hate to put you on the spot, but I am going to, because, you know, we were very careful not to, in our opinion, violate the government code because we do understand the importance of it. So I just want to know if it's your position that the judge, a trial judge, has to sit in the courtroom for every hearing. Because we're carving out jury trials. We don't have to worry about that. We'll get that changed. I never thought this rule applied to jury trials anyway, but so Kenan and I disagreed on that. But I want to understand what you think the senator's position is.
Well, I don't know. So let me be real clear. I do not know what the senator's position is. And I would not speak for any individual member of the legislature. I do feel like I heard that the initial effort of OCA to have kind of this being something that could be done despite objection by the parties was not well received because of the belief that the courts are supposed to sit in the jurisdiction according to the government code. Now, you know, the interpretation of what the government code means is to people like yourself and higher than me. So I can't say that the language in the government code says you've got to physically be in that position, but I'm sound Trumpian. There are some people who say, I've heard it said that is their belief. And I think one of the frustrations that I will share with some of those thoughts is all of this law comes out of the emergency authority of the governor to declare a state of emergency. That then under, again, the statutes of the state of Texas gives the court the ability to issue the orders that it has been writing. There was a whole lot of debate about the governor's authority to declare this pandemic a state of emergency for perpetuity. And there is a political discussion around that. Are we going to have a state of emergency forever? You just have to be, I just wanted to be on the record to say there is a political component of this that will question whether this is a substantive touch upon the government code. Was that a political enough answer for you? That was an answer, non-answer?
If I can ask you,
we know for sure in the appellate court that we have the authority to do this, even at the intermediate courts. And then the real question, and we have thought about it, and we did think about it, is, you know, does a judge have to physically be sitting in the courtroom to conduct business, right? And that does actually not preclude remote proceedings. Because I know, for example, Judge Schaefer sits in the courtroom the vast majority of the time when he's conducting remote proceedings. And a lot of judges down there do that. And it's a way to avoid the sort of worries about, you know, everyone's business going out on YouTube, which, you know, we'll get to later, maybe, which we've tried to address in our task force work. So, but you know, if you have heard, that would be something that would be interesting, and you know, we would like to know that, because that's something that can be done, really. That, you know, the judge has to sit there. Now, you know, that wouldn't help Judge Esteves, who, you know, was able to do her, you know, jury dockets that way without, I suppose if you were sitting in your courtroom, you could.
I think litigation.
I've done it both ways, but I will say that in our criminal ones, we make them sign a waiver that also waives where I'm sitting. So they're waiving the fact of they're not complaining about where they are. They're not complaining where I am. They're not going to complain about where their lawyer is. We make sure we waived everything.
So if it's a concern, it can be addressed. So that is why I wanted to know, because we don't want to run afoul of the government code. We don't want to run afoul of accountability for our elected judges and judges sitting in certain areas and all of that. We do not want to do that. So,
Justice Christopher, you said that Jim came on quite a bit stronger early on when he first made his remarks.
Seemed to me that he did. Perhaps I was just
if we had just been in person, you would have seen how nuanced his presentation was.
amen.
Maybe so.
Amen.
All right, I think we're back to Orsinger, who is, and by the way, there's no filibuster rule here, so get after it, Richard.
Okay, Chip, thank you. So to touch on, I feel like we're not making a sufficient record for the Supreme Court on what I consider to be the core issue, which is who makes the final decision. So I want to return to that briefly. I doubt that few people would argue that a trial judge can force a litigant to call a witness live when they've done a videotape deposition and want to play the videotape deposition in the trial. Maybe somebody would, but I don't think anybody would. I think that a party has the right to call a witness by deposition, in which event you're not going to be able to see and touch and feel and smell the witness while they're on the witness stand. I have a hard time understanding what's the difference between playing a video deposition and having live testimony of a witness remotely. In fact, I would argue that remote live testimony is better than videotaped testimony in terms of subjecting the witness to examination for credibility and things of that nature. So while I think probably few would advocate that a trial judge can force a party to call a witness live when they want to play a video depo, I have to ask the question of why should a judge be able to force a party to call a witness live when they want to have them testify live remotely? And if you agree that a party should have the right to call a witness live remotely, what is a trial but a succession of witnesses? A Zoom trial is a succession of live remote testimony. If remote testimony is tantamount to deposition video testimony, I don't get it why the trial judge could order a party to, or require a party to present the testimony by a live witness on the witness stand instead of remote testimony. So I think one of the questions to answer here is, does a party have the right to call a witness live remote, regardless of the judge's desire, or does the judge have the right to force that the testimony be live? And that's true for one witness, and that's true for a succession of witnesses. Now, then the next question is, can a trial court force on an objecting party the requirement to be in the courtroom for the trial, to conduct a live proceeding where everything occurs in the courtroom? Can the court force that on an objecting party that wants to do it remotely? The next question is, can a court force it when all of the parties agree that it's going to be one way and the judge wants it the other way? If all of the parties agree that they want to be live and in the courtroom, can the trial judge override them and force them to try the case remotely? If all of them want to try the case remotely, can the judge override them and force them to try the case live? In other words, ultimately, we have to discuss and decide when or who has the final say, and whether one objecting party can kill it for everyone, or whether two parties in agreement can override the judge, or whether the judge can override everyone, including two parties that are in agreement. To me, that's a really, really important discussion that we need to be having. Now, then, putting that aside, it's possible that we could relieve some of the pressure on making the decision right now by having tiers. We have tiers in discovery, level 1 and level 2. And level 1 cases under Rule 190.2 are $50,000 or less. So that's one possible cutoff where we've already compromised some of the due process based on the amount in dispute. We also have Rule 169 on expedited actions, which requires consent. But everybody has to agree that they're not seeking damages over $250,000, but they're in a consent environment. We've allowed due process to be altered, I would argue compromised. In the family law arena, I would say an area where we should probably mandate it, no matter what anybody wants, is the prove up of uncontested divorces with no children. I mean, I could see you could justify a rule that all judges must abide by, that uncontested prove ups of divorces with no children have to be remote for anyone who wishes to be remote. So I feel like we can reduce some pressure on our decision by initially limiting it to a dispute, or initially limiting it to consent from both sides, initially not trying to force it on a jury trial, initially not trying to force it on a non-jury trial. But it does seem to me that if both parties want to try it remotely, even though the judges that we were talking during the break all agreed that the judge should have the final say so, I don't ascribe to that. I think that the parties' views should be considered to be very important, if not as important, or perhaps even more important than the judge's preference about live versus remote. So anyway, Chip, thank you for allowing me for the 10th or 12th time.
Always love to hear from you, Richard. Roger, you're next.
I'd like to go back to what we were talking about, the potential political overlay about, so to speak, not trying a case in the county seat or wherever it was. You know, the whole purpose, I think, historically, in fact, going back thousands of years, of having a court sit in a particular locale was as a convenience to the local population. Just like in back when the king traveled around in England, that's wherever the court was. You had to go run down the king. And he might be on the other side of the channel fighting in France. He might be in London. He might be in some other city. And so we had judges meet in a particular place and they could dispense justice. And so now we count on each county to fund phenomenal amounts of money. And then every 4 years, we have very expensive elections where all kinds of money, large sums of money, are raised in order to elect this or that judge. And now all of a sudden, is this judge really going to preside over this community? My point is that on one hand, we may have laws now that allow incredible flexibility to the local judge about where proceedings are being held when they're being held remotely. Do I have to be in the courtroom? Can I be out in my fishing lodge, my fishing cabin on the bay, whatever? But the point is, there is a legislature looking over our shoulder. And there are the local people who talk to their legislatures. And we may be able to persuade the Supreme Court to enact some of these rules, but there may well be pushback, and we have to think about that. And it's part of the value, or I think the purpose of having local courts sit in a particular locale is not just so that people will know where to go find them, but to feel like these judges have a connection to the community. If all they are is talking heads on a TV, how do we know they have any connection to our community? Why should we support them? And, you know, it's not been in the distant past when we've had arguments to create special courts with statewide jurisdiction to handle particular classes of civil case in order to take certain kinds of civil cases away from, you know, local courts, which they are selected under our venue laws, and instead transfer them to a high-powered court in, let's just say, Austin. And that didn't go over very well. I could see possibly that if we really want to push this to the limit, we could centralize all the district courts in Texas in one particular county, because that's where we have the supercomputers that can handle all of the server loads, et cetera, et cetera. And all the district judges will have to run statewide elections, and which basically few people will know anything about the district judges who are going to be sitting on their cases, except that they're in this distant place called, I don't know, Travis County, Harris County, wherever the big courthouse is, and that might be very, very efficient, and it might make certain classes of cases easier to try, and make certain classes of litigants feel more confident in their decisions. But I'm not sure the public will go for it. And they may not feel their tax dollars are being spent as wisely. And now the other thing of it is, it was thrown out earlier, then in terms of deciding the judge's power to override a litigant's decision about whether to have remote or Zoom jury trials, we do it by classification of amounts involved, or by subject matter or types of cases. All I can say is that is going to make certain litigants feel they are second class. In other words, I'm sorry, your case is not worth more than $100,000, so you don't get real trials. You get TV trials. And the public may begin to feel like justice is only for people with big money who have big sums of money to gamble with at the courthouse. And I sympathize that certain other types like family law, et cetera, will be carved out and they will always get to override the judge. But there's still the problem that at the moment we start saying certain types of people get real trials, the Deluxo, Cadillac or Mercedes-Benz of trial work, and the rest of you, I'm sorry, your case is under so many dollars. You only get a TV trial. I think you can imagine what the public's going to think of us. So I'm sorry, I've said my piece. Thank you much.
Public's going to say, you mean I get to be on TV? John.
Just two quick points, because part of the first part that I talked about was there's a difference in this academic theoretical discussion versus reality. And to address the issue of depositions and witnesses, it happens all the time where judges force you to bring the witness live. There's a rule on it in federal court. It's called what is the federal definition of unavailability of a witness. And the reason for that is because credibility is better determined in person with an actual face-to-face confrontation. That's in the federal civil rules of procedures notes concerning the adversarial right of a cross-examination in civil cases. And so I think it's really important because I don't think you will find a single social scientist or a single jury scientist who will sit and tell you that the ability to see someone's face clear on a screen is the best means for determining a witness or a party or an attorney's credibility. And so it is that entire experience that we are trying to preserve. And we're going down a slippery slope with this with respect to advocacy and really Seventh Amendment principles. But I want to underscore everything I just said before and now, that I do think for the vast majority of proceedings, Zoom is fine. It's only when you have a situation, bench trial, evidentiary hearings, jury trials, where credibility of witnesses and testimony is important, that I think we have to be very, very careful. Thanks.
Thank you, John. Judge Miskell.
One of the things I wanted to center our discussion back on is this is why in our subcommittee discussions, we got away from talking about remote proceeding and talked about remote appearances, because it's like a ship of Theseus problem to say, when does a in-person proceeding convert into a remote proceeding? How many participants have to be remote before it's remote? If we take our time machine back to 2019, I could allow a witness to testify by phone or by video. If a party objected, the judge could overrule it and allow it anyway, or the judge could deny it and say the witness could not testify by phone or video. An attorney could request to make an appearance by phone or by video, and the court had the power to allow it or not allow it. The court didn't need a permission slip from the governor. The court didn't need emergency orders from the Supreme Court to allow a witness to appear remotely or to allow an attorney to appear remotely. And the parties never had the power in 100 years since 1914, when the first cases on the telephone came through the system. The parties did not have the power to control the judge's outcome. So I don't know that this is any different, what we're talking about now, than the court's inherent power to always have allowed that or denied it. I don't see that anything about an emergency order from the governor or the Supreme Court has changed the fact that that was always held to be within the court's inherent power. So I'll just leave it at that.
Yeah, just to comment about that, Judge, to me, it's part of it's the frequency it's being used now. I mean, I know it was used a lot to certain degrees, but the frequency now, but also, we're coming off 2 years of being, cooped up and masked up, and there's all this frustration about being separated and taken apart, pulled apart from each other. This meeting being a good example of not, we were going to be in person and now all of a sudden we're not. And I think there's all that frustration that is bubbling over into this discussion. Not to denigrate anybody's position on either side of this question. I just think, the place we find ourselves right now is influencing a lot what people think about this issue.
Absolutely. And my main point is, as I said at the very beginning, I don't want to throw out things that have already been inherent in our system when we try to change something for Zoom and act like some things we haven't already been doing the whole time. I'll just tell you how I do think. People think I'm some kind of Zoom zealot, and I'll tell you I'm not. I'm setting all my trials and contested evidentiary things in person. And the reason for it is people settle their cases more when you make them come down to the courthouse. I totally agree with the judge that said, when you allow people to do things on Zoom, it's too convenient and they won't settle their case. They'll just say, let's talk to the judge. Let's take a swing at it. So anyway, I'm setting stuff in person, but I will tell you, every single day, there's some reason somebody needs to participate remotely. Judge, I'm set in another county. Can I participate remotely? Yes. My witness has been exposed to COVID. Can they participate remotely? Yes. My witness is out of state. Can they participate remotely? Yes. So even though I fully intend to have my 9 a.m. docket every morning be a fully in-person docket, I'll tell you every single day, there's like 3 or 4 non-in-person people. So I think that is the world that we're going to. And I understand if people don't think now is the time to address it with rules. I also don't want to steamroll over it and not be cautious. I 1000% agree with all the people that said we need to slow down and think about the complexities. Absolutely. Our subcommittee came up with a starting point to spark a discussion, and we obviously successfully did that because our discussion has been sparked and everyone's interested. And I think it's great that we are focusing on how can we bring more justice to our vulnerable Texans that lack access to our in-person courts? How can we protect the types of trials that benefit from fabulous high-paid lawyers and their fabulous jury arguments and all of that? It's wonderful. Let's have a system that works for everyone at all ends. And I agree, though, the reason it didn't go anywhere in our subcommittee, it looks terrible, even though we say we're helping those low dollar cases, because those are the ones who can't come to court and those are the ones that are best served by Zoom. It looks terrible, like we're relegating them to some kind of lesser justice. So I don't believe that's a realistic option. But I do think we need some way to protect our vulnerable Texans that have been excluded by our in-person system.
Yeah, very well said. Thank you, Judge. Harvey. You're muted, buddy.
Thank you. Sorry.
That's all right.
Richard asked the question earlier as to who should be the decision maker, and I wanted to address that for just a minute. I don't think it can be the lawyers for reasons that have been already stated. And I thought Judge Schaefer's example about the Houston lawyer that would demand that the Dallas lawyer come down here every time was exactly on point. There are lawyers who will try to exact a cost on the other side by making them come down to hearings, whether it be in the same city or elsewhere, where somebody's just going to say, I want to drive up the cost. I want to force them to settle. Do everything you can to drive up the cost. And that does happen. And I think the other example was the prisoners who couldn't appear before. So a lawyer in that case might say, no, I don't want anybody to appear live. Remotely. I want everybody to have to appear live. So I just think the only disinterested person on that decision is the judge. So the judge should make that call. And I do think that the judge should also be able to override the lawyers for reasons that are kind of unique to the judge's position. First, I just had a hearing about a month or two ago where a lawyer, it was remote. Obviously, I'm not a judge, but I was an arbitrator. And the lawyer started screaming at me. And, I put my hand up. I tried to stop him, et cetera, et cetera. I had a really hard time gaining control of that hearing. And after he finally calmed down and, the hearing kind of gotten back on track, I said, if we were in a courtroom, you would never have spoken to me this way with my bailiff here or in an open proceeding. And it's just an example. Sometimes things happen on Zoom that a judge just doesn't have quite the control they would have in the courtroom. And I think the judges need to have that ability to control. I also think some judges just aren't as comfortable with that. The first few Zoom hearings I did as an arbitrator, I just didn't like it as much. And I'm sure that there's some judges who still feel that way today and just feel like they do a better job. If they feel like they're doing a better job, I don't think we should say, you're not. We're going to force you to do something you think that makes you less than your best. I also think we've talked a lot about credibility of witnesses. As a judge, sometimes I want to look the litigant in the eye. I need to look at credibility of the lawyer sometimes too. Lawyer credibility is also important for judges. And so sometimes you want the lawyers in front of you for that. And finally, the phrase was used earlier about not making it too convenient. I remember when I was a judge, there was a case that was having difficulties. So I just did a hearing every Friday. Well, guess what happened? The number of motions that got filed just tripled. And a wise, more experienced judge said, you made it too convenient. You made it too easy. They're going to fight over everything. And I learned a valuable lesson about that. And I do think that having a little bit of skin in the game, a little bit of cost is something that judges can use wisely sometimes and say, I'm going to make them come down to the courthouse if they really want to fight over these issues.
Thanks, Harvey. Robert.
I just wanted to follow up on a couple of items. And one of the questions that I would have for Kenan and Judge Christopher is, why not make this issue presumptive that in-person trials or in-person proceedings, in-person participation would be the norm, and that if there is a reason for having somebody remote and whether it's a participant or the actual proceeding itself, a good cause to go remote, then why not do it that way? Because what the proposed rule suggests is there's no preference either way. Kenan, put that to Kenan. Yeah.
And that's certainly an option, but I think it's important for us to dig a little deeper and consider that in some of these cases, for example, the CPS cases that have been cited repeatedly, the child support cases, the uncontested prove-ups of divorces, the presumption that in-person is better may be faulty. So that's something I think, when you start to dig beneath the surface there, if you were going to make that the presumption that it's better, you would have to think it seriously and ask the question, is it really better in all types of cases?
So this is my issue with that. You're changing, 200 years of jurisprudence and practice and making a presumption that remote is just as good as in person without any real foundational basis other than 2 years of experience. We've had obviously 2 years of experience. We certainly know what the numbers are, but we don't yet, as far as I know, have any perspective from academicians or studies to understand, is it better or is it worse? Or is it better in these types of cases, but not better in other types of cases? What are the consequences? What are the long-term impacts? Obviously, sitting here, we can give our own perspectives, but they're not worth that much. Obviously, the judges who have had hundreds or thousands of proceedings remotely have a strong factual perspective, but it doesn't count as evidence. It certainly wouldn't be evidence that would be admissible as expert testimony. And yet we're talking about a gargantuan change without knowing, is it good? Or could it actually have a long-term negative consequence on our system? And it's not just jury trials. Judge Miskell said 90% or 80% of the complaints relate to jury trials. That's not the case. It is much broader than that. And one other point I wanted to elaborate on Jim Perdue's comment. Yes, the legislature feels very strong about this, particularly when that bill hit the Senate. And if we're thinking about making a change that gives the judge total discretion on remote trials, I think it's very likely the legislature will step in and do what they almost did, which would be to prohibit them, which is not what we want either, remote proceedings, because I think we want the option. We want the flexibility. We want judges to be able to do it if there is a good reason. But I strongly suggest that it would be wrong to make it an either or option, just whatever the judge felt like doing. And because that would be such a massive change that would be very disruptive.
Just a couple points in response. I think, you said I'm making the presumption it's better. I'm not. The rule is drafted to be neutral and to give the trial court judge.
How do you reach that?
If I can finish,
yeah.
Please. It's drafted to give the trial court judge the final call to exercise discretion. And I think, the question you posed was why not make the presumption that in person is better? And the question I'm asking in return is whether that's true in all types of cases. So going back to the rule, I think if you're going to presume one is better than the other, I think the full exercise and thought process has to be, is in person better for certain types of cases? Is remote better for other types of cases?
Well, I can make an argument that having a non-jury trial is better than a jury trial. It's more efficient, it's less disruptive, it's more likely to result in a consistent finding. But obviously, that's not how our system works. And we're not going to change that. And I'm not suggesting we ever would. But you don't change an established precedent and say, let's do it differently because it's worked sort of for the past 2 years because we had no other choice. And so let's make that fundamental change without even knowing that the evidence and studies show that it's actually equal. And yeah, there might be proceedings that are absolutely better being remote. I don't deny that. And by the way, I deal with technology, so while I am a baby boomer, I am strongly supportive of use of technology. But it doesn't mean that just because it has succeeded because we didn't have a choice in the last 2 years, doesn't mean that we should fundamentally change presumptions, which are, in my view, that a jury or in-person proceedings would happen unless there's a reason not to.
And that's certainly one way to approach the rule, Robert. It's just something I question is, are we looking through the lens of the way it's been without these technological tools available to us a little too much? Because, we talk about how it's been for all this time. Yes, it was in person for all that time because Zoom wasn't even possible, right? And what we've learned during the pandemic is we can do a lot more remotely than we ever thought we could. I mean, at the beginning, I spoke with many people who said, no way, no how you can take a deposition via Zoom. We had lawyers in my firm saying, we need to write motions, say no way, no how we can take this deposition via Zoom. And those same lawyers took multiple depositions via Zoom and said, hey, we can do this. And we've saved clients money by doing it this way. So I want to just open our minds to the possibility that we can do more than we thought we could before, and we have technological advancements that have occurred that give us the ability to change our ways. And in doing so, we can increase access to justice.
I totally support that concept. And I'm not saying we have to stick to the old ways because they're the old ways, but I am suggesting that we need to be a lot more hesitant to make the type of fundamental change that the task force recommended, because it is presuming everything's going to be just as good or better. And I don't think we know enough to make that judgment. We know, yes, you can do it. We know there are problems and limitations, There are also problems with in-person proceedings. But we know in-person proceedings do function and they have a long-term history of functioning. And until I think we have a lot more of a track record, we shouldn't just automatically say we can do either and depending on what the judge wants.
And one question I have for perhaps Chip is whether it might be worthwhile at some point to take a vote on whether jury trials are carved out, because it's a little difficult to ascertain, at least for me, how much of the resistance here is about the concept or possibility of jury trials going forward remotely as opposed to other types of proceedings. So I want to be sure that the debate we're having is as productive as it can be at this point, and it might be enlightening to figure out whether if we took out the jury trials, it would change the views of some of the people of this committee.
But can I point out that, as Kenan noted on the JP rules, they're specifically talking about trials. I guess they don't do jury. Well, they do. They can do jury trials.
Yeah, sure.
Yeah. And you know, that working group wants jury trials included. And if we changed it for civil, it would be kind of on a dollar value sort of issue, but we can do it.
When I had the JP docket for Jackson Walker, I always demanded a jury in JP court. I got about 20 jury trials before I was a third-year associate. They weren't very long, but all right, back to John Warren.
I was almost at the point where I forgot my comment. This has actually been really wonderful dialogue, but it actually goes back to my original statement where I said, I wish we could have done this 3 years ago, but the pandemic prevented us from doing it. I'm talking about me and the things that I was working with a couple of the judges in Dallas County. I have a criminal court judge who uses court call. She has not been to the courthouse since March of 2020, but she is one of the most phenomenal in that she is able to embrace the technology and using court call to do her docket solely virtually. And she has she has done a lot more cases than anyone else. But that's because she embraced the technology. At some point, we need to get there. With everything that I've heard, it goes back to what I was saying as it relates to everything that we need to actually put on paper as it relates to pros and cons, point, counterpoint, if you will, as it relates to how the direction that we're going to go to. But at the end of the day, it comes back to President Kennedy when he said, we go to the moon not because it's easy, but because it's hard. At some point, virtual processes has got to be part of what we do. And I said virtual processes. I didn't say trials, virtual proceedings, because at some point, I actually don't think a jury trial will fit in this category. Because as it relates to what Tom Rainey said, how can a young lawyer who aspire to be a judge has the ability to understand how to preside over a jury trial if you don't understand that concept? I think a jury trial is absolutely essential to molding and grooming young lawyers so that they can at some point become a jurist. But at some point, it goes back to how do we manage a docket? How do we get things going? Chief Justice Heck said it's going to take approximately 3 years in order to get rid of the backlog. At some point, we have to start thinking outside of the box. Virtual processes is outside of the box. I applaud Judge Miskell and Kenan Wooden for their efforts. I'm a baby boomer, but I'm one of those baby boomers who are more like a generation X, Y, or Z or whatever. I love technology. I embrace technology because that's the direction where we're going. Otherwise, we may as well put phone booths back on the corner. People don't understand technology and the things that we're doing as it relates to Zoom and all the other things. That's nothing more than shopping on your phone. the way we are doing business. I mean, and it's good to have this argument, because at the end of the day, when we present something, whether it's with the legislature, with the change and how the rules are written, we have to be able to say, with all of the things that people will say as it relates to, did you take this into consideration? Yes, we did. We've taken that into consideration. That's where we're going. This has got to happen. It has to happen. I said, I wish it would have happened 3 years ago, but as you know, with the pandemic, and I think it was Judge Miskell said, I mean, what we've learned as it relates to changing processes in the middle of a pandemic. I always say in Dallas County, we've had to change the tire while the car is in motion. That's a requirement, because we cannot slow it down. It's necessary, it's important, and we have all got to get there. I think all of the dialogue that I've heard as it relates to the things that we need to take into consideration, we need to document those things so that we can take those into consideration when we actually come up with what is best practices for virtual proceedings. And Chip, and while I love everything that everybody has said, I think we beat the hell out of this horse, and it's time for us to move on as it relates to what we need to do. And I would actually, no offense to Roger and Lisa Hobbs and the Tarrant County Judge David Evans. I actually worked for David Evans in Dallas County. So, but I think we actually need to say, okay, these are the pros and cons. These are the things that we need to take into consideration, or have you considered this? And that's what we actually document, so that Ms. Wooten and Judge Miskell and the rest of the members of the committee can go down the road as in making what we hope will be what's new in Texas. Because I can imagine these conversations taking place in California, Illinois, New York, Florida even, but does Texas always have to come in last? We need to get there, and we need to figure out how we're going to get there.
Well, some would say that we've come in first on a number of different rule proposals over the years, but John, as a rookie to this committee, we haven't begun to beat this horse to death. I mean, this horse is going to be well beaten by the time we're done with this. Roger, you're next. Thanks, Roger, but you're on mute.
Well, I don't want to continue to say like I'm sounding dystopian or whatever that's going to be. But I think one thing that argues in favor of proceedings stepwise and not making big steps, et cetera, is something I said earlier. And that is, sorry about my clock. And that is, we may find out that this technology was not as wonderful as we thought, that it is not the great leap forward. I'm old enough to remember when everybody embraced videotape depositions. It was the wave of the future. That's how we're going to try cases. We're going to have everything videotaped. It'll all be in the can when we walk in the courtroom. We just put it in the VCR. Some of you may remember what a VCR is. And just play it for the jury. And then we found out that after 15 or 20 minutes, jurors went to sleep. And so all of a sudden, you had to learn that maybe a videotape deposition was not the wave of the future. It had a use, it had a purpose, but it could blow up in your face, or it could just not be as wonderful as you thought. It wouldn't do that. And then there was the audio-visual generation. The people who wanted everything in video displays, video charts, video graphs, animatronic, animation present. That was the wave of the future. We brought in the projectors and the screens, and the everything was on. Push the button and you got a magnificent CGI display. And then once again, we found out, no, that was not going to take over trials either. It had a use, it had a small purpose. And we didn't have to wholesale, but unfortunately, we didn't have to do a wholesale revision, a massive sea change of the rules of procedure to make it work. And then, of course, I won't even talk about, electronic discovery of electronic data. That we'd be here for the next week. The point is what I think is that if we have had 2 years where we have been forced to make great sacrifices and to do these things as a crutch, as a make do, and now it's here and we might be able to use it. But I don't think it's going to turn out to be the be all and end all and the wave of the future. And that's why I don't mean to sound dystopian about it. I think what we're going to find if we take it slowly is that it has a place, it can be useful. And if we don't rush headlong into it, we soon will be able to trust a judge to say, nope, you're going to have to do it live. Nope, you're going to have to do it remotely. And we might even develop, after we develop that level of trust, we may be able to articulate a standard when the judge may or may not have abused his or her discretion on the matter. But that's not going to happen if we just pass a rule and jump. And so that's my comment. Thank you.
Thank you, Roger. Lisa.
Well, I was kind of thinking I might be able to say, well, Roger should support this rule until like the last little trail off. I just want to emphasize that this rule is not compelling remote proceedings, even in non-jury trial cases, which I think we might have all agreed that we're pushing off. This rule authorizes remote proceedings within a trial court's discretion. And I think I agree with other judges who've spoken today who said, I think I would have had the discretion even without a rule. But the fact is that we had these emergency orders where we had clear authorization from the Supreme Court that said, you can hold this stuff remotely. And now as the pandemic dwindles and our emergency power might end at some point, these rules are just saying, hey, you, trial judge, have full authority to hold a hearing remotely. And we can debate what Richard Orsinger has been asking us to debate. He might want to jump up and down one more time and say, can we really get to the big issues here? When a trial judge can do that and when a trial judge can't, and under what circumstances with the parties or not. But ultimately, if you stand up here and tell this committee that the Supreme Court is compelling remote hearings, you are talking past the subcommittee's work. Because what we were trying to do is authorize committee hearings. And you can disagree with us on when it should be authorized, but no one is standing up here saying we are compelling remote hearings by trial court. That is not on the table at all. So please stop saying that. And if you think it should not be authorized, then that's a very different discussion. And it's not like what I'm hearing today. You're basically saying it should be prohibited unless the parties agree. And if you want to make that argument, that's fair and great. But that's not what you're kind of playing this middle role, and you're saying the subcommittee recommendation is doing something more than the subcommittee recommendation is doing. And then you're not proposing, okay, well, let's hear how you would word it. Would you say that unless the parties agree, you have to have in person in every case? Or in not every case, but in these cases? But let's come to the table fair and have the same conversation, because some of the conversations that are being had right now are not in relation to the subcommittee's report, and no one is proposing them. And so, that was my point. This is an authorization. We know the Supreme Court no one has challenged so far the Supreme Court's authorization to do what they did during the pandemic. A lot of people like it. We want to authorize it. We want it to be within the trial court's discretion. No one is compelling it in every case at every time. And we're trusting the judges because honestly, that's the rule that we thought was best from the subcommittee perspective. If you have a better rule of how to rein in the trial court's discretion, propose it. But we decided that we want to authorize it and we only know how to give it to their discretion. We trust our trial judges. And so that's the rule that the subcommittee is proposing.
Thanks, Lisa. From my perspective, nobody's attacking the subcommittee's work or its rule. That's for next meeting. We'll do that then. This is all therapy. We're just all having therapy here on this.
Therapy?
On this go around, yeah.
I don't think Ken and I feel like Ken and I need therapy after this. So.
Yeah, listen, I'm gonna get my buddy Dr. Phil and he's gonna fly out and see you guys. It'll be all fine.
I'm just glad I'm not paying for this therapy and I'll stop there.
If we were in person, we'd be drinking, so.
Yeah, well, that's true. In a few minutes, if not before. Yeah, don't worry, Lisa. We're gonna come back and we're gonna have a good discussion about
but I just really, I mean, my point is not that we feel attacked. We don't. We all have thick skin. Ken and I have been talking on the breaks and by text every time you guys are proposing something. We're not thick skinned. I mean, we're not thin skinned, trust me. But my point really is just talk about like actually what we're proposing, which is not compelling remote proceedings. It is actually giving trial courts discretion to decide in each particular case whether they're going to have remote proceedings or not.
Yeah.
And I feel like sometimes the conversation's going way off into not that.
Yeah, for the first time ever in this committee, we've wandered off point. Incredible.
Shocking.
Yeah, shocking. And nobody thinks, by the way, that either you or Kenan have thin skin. We know that you have, reptile thick skin. And next meeting, we're going to try to penetrate it and see if we can get to you, but not this time. So Judge Evans, you're up. And don't say anything mean about Lisa or Kenan, okay?
Just say boom or be quiet when you're ready for me to be quiet. I support allowing hybrid or remote proceedings, but I think that in the proposed rule, when I read it, I wanted to share this because it relates to the standards, the discretion, and the abuse of discretion. When I read the proposed rule, I think it's 18C, it said the rule and any standards adopted by the Supreme Court. And I thought, well, how are we going to do this without the Supreme Court adopting standards for when you allow somebody to appear remotely or don't, or guidelines? And here's the problem I think that the judges and the committee needs to keep in mind from the trial lawyers. If this is an abuse of discretion standard, what are the guiding principles? And would there ever be an appeal that would have a harm analysis that would lead to reversal? So I think why the trial lawyers are uneasy about this is not the rogue judge, and yes, they do it, is just that how do they get relief when they think that decision is bad? And I'm not inviting interlocutory appeal. So Justice Christopher, do not send in lightning darts toward me. I'm just, you and I both know we're talking about mandamus. Now, interestingly enough, 25 minutes ago, I received an appeal from a lawyer in my region asking me to intervene with a trial judge because the lawyer wants an 81-year-old witness in California to appear in a proceeding. Now, I don't have the authority anymore on that, so, I'll probably do the best little whorehouse in Texas, dance to the left and dance to the right, which I wanted to send to you, Jim, a few minutes ago, but anyway, I thought I'd just send that out. And John, why would you compare me to David Evans in Dallas? I mean, golly, that's all I have. The problem is abuse of discretion. Where do they get relief? And it's got to be standards written by the court.
Yep, fair
I'm
enough.
sorry,
I think that's got to happen.
Chip, I'm sorry. I have got to respond to that.
Yeah, well, I would think you'd want to.
Judge Evans, I can tell you that Judge David Evans, who was the in the 193rd District Court in Dallas
I'm
County.
Judge David Evans. He's
And-
David
and I-
W.
and I-
Evans. I'm
actually,
David L. Evans.
I remember when you ran, everybody was confused because they said, "Did he move to Tarrant County to Judge Evans moved to Tarrant County to run?" And so we
No,
had to straighten
they
out
said,
the
is that bad-tempered judge over in Dallas, or is that in Fort Worth, or the nice guy in Dallas? I know what's bad.
No, actually, David Evans, he was phenomenal. He actually fostered my passion for courts and technology. So, and he always challenged me. So, and I'm assuming you're doing the same thing over in Tarrant County because you're on this committee. And based on everything that I'm hearing from you, there is very little difference between the two of you.
All right, you guys go get in your cars and drive to Grand Prairie and hug it out, okay? Rusty.
I'm just joking with
I think all of us embrace technology, even if those like me don't know how to use it. All right. So I don't think the argument is against technology. I don't think the argument is against having remote proceedings. As it comes down, it sounds to me like we're back to where Richard was. Who makes the decision? And at the end of the day, and if we take what Judge Evans is saying is, if you leave it in the discretion completely of the court, you are having basically compelled remote proceedings because the judge can compel it and the litigants can't. And so you're really talking about, can the judges always compel it? Or are there going to be such procedures that have certain presumptions that have to be overcome to do it? But, you are taking it out of the hands of the lawyer. So the irony of my feelings and sort of impulse here is it runs counter to what I've been saying since I've been on this committee, which hasn't been anywhere near as long as most of you. But I've always been a champion of discretion of the judges. And I've always believed that when we couldn't decide what the hell happened or should happen, that I was more comfortable with judges having the discretion. But something like this takes total control of the litigants if we're not careful. That's my only concern. If I can be always compelled to be remote on whatever the proceeding is, let's assume from my comments and everybody else's, we take jury trials out of it. But if I can be compelled to be remote, and it's just a matter of that judge's decision as to whether I'm going to be, then I'm losing the opportunity to, quite frankly, effectively as I want and believe is appropriate, represent my client. If we talk about cost proceedings, I've always assumed that the lawyers want to solve cost proceedings for their clients too. And if it's a matter of cost in remote proceeding in this situation would be to the client's advantage economically, then it's hard for me to imagine the situations where one lawyer is going to say, there are lawyers who want to run you into the ground maybe financially, but most of the time lawyers are going to choose, I think, a remote proceeding if it doesn't have them give up the interest of their client by being able to in person address the opposing party and the witnesses. They will agree to them. I think everybody knows that we benefit in a lot of ways from remote proceedings. The issue is going to be is what's a remote proceeding and who makes the decision. And then if you're going to leave it with judges to where we don't get to, I have a hard time imagining what's wrong with letting the lawyers agree. I mean, is it really that bad? I mean, most judges will say if the lawyers agree to something, unless it's something unethical or improper, I'm going to usually endorse that. And I just really think that it's unfair to the litigants at the end of the day to be compelled to do something remotely. Voluntarily, I think you'll find that just most trial lawyers are more than happy to do a lot of things remotely. They're going to be interested if it's a contingent. We do both plaintiffs and defense on the civil side. The contingency lawyer doesn't want to run up the cost. That's money out of his pocket. And so I think that when it is appropriate in a more efficient way, most of the time, the litigants will choose to do it remotely. The issue is, should they be compelled to when they believe that is against the best interest of their client? And if they are, what are the standards the judge is going to be guided by, so that, as Judge Evans says, is if we want to challenge it, what is our likelihood of success on the view? And in all deference to every judge on this committee, there are some judges that are going to compel people because of convenience. And let's face it, what I noticed when I started out in practice and became friends with people who then were practicing long enough to become judges, I would watch them and talk about, and I know we're taking jury trials out, but the principle's the same for presiding over other matters too. The biggest champions as trial lawyers of the jury trial and jury selection were the trial lawyers who then, I think unfairly, that Jim was accused of having changed his position a little bit. I'd send out a figure of unfairly. I think you and Lisa can get together on this thing, Jim. I think both of you have been unfairly treated. But I will say this, that all of those people that became judges, the first day they've got to be judged, they hated jury selection. They wanted to cut it. They wanted to cut this. The trial needed to be streamlined. There were very people 1 week before that were extolling the need for lawyers to be in control of jury selection, et cetera. And so a lot of judges are going to make convenience decisions. In all due respect, and we litigants and our clients, it's not about us, it should be about the clients. We think it's not to their advantage. So if we take jury trials out of it, as been suggested by Keenan, and then let's talk in terms of this, maybe through a vote or whatever, Chip, you decide to do on it. At the end of the day, we're going to have to face this issue. Who gets the absolute right to make the decision? And if it remains judges, how do we be able to challenge that? We'll have a decent chance of success if we're right. That's it.
Thank you, Rusty. Justice Christopher.
Yes. What I think would be useful is if we could articulate in writing what we would think would be good cause under this 21D, right? 21D says the court may allow or require a participant to appear remotely. Okay. The committee report on good cause is limited. And what I'm hearing from a lot of lawyers in the group is they want the good cause to be more, to give examples of a more expansive good cause, right? So a good cause can exist if the parties agree to a different manner of presentation. Good cause can exist if the size of the case or the complexity of the case requires an in-person proceeding. So those are the kind of, specifics that we could, which I understand Rusty's concern of, how do I get relief to be more specific. So we've talked about if the parties agree. We've talked about it's a really complicated case and, we just need to be in person. We've talked about the other side's a liar. And I know they've been cheating on depositions. So, please don't let them cheat by having a remote hearing or proceeding. What other sort of things that we could put in just to flesh out the idea of good cause? I'm not opposed to that. I think that's a good idea.
Great, thanks, Judge. Judge Miskell.
I just wanted to respond on the reasonable lawyers will agree in advance. One of the people that remote trials help the most are our pro se litigants. So on my docket, it's about a third of my cases are pro se on both sides, a third of my cases are pro se on one side, and about a third of my cases have lawyers on both sides. And with the pro ses, you just don't have communication with them in advance of the trial. We send out a notice and they show up or don't. And so one of the best ways I would like to use the tool is to help those litigants not be default judgments, help them be able to participate by setting their case for trial remotely. But if it requires agreement, I will not be able to do that because we don't have two-way communication with them in advance of trial. Those will just be set in person and become default judgments, which I don't think is as helpful as we could be in helping the litigants that our system is supposed to be serving.
Thanks, Judge. Rich?
Just to echo on that a little bit from the lawyer's side, I live in Dallas, but for some reason I have had a ton of cases in Hidalgo County. Getting from Dallas down there is not easy. If I have a 30-minute hearing at 9 o'clock one morning, it's a 2-day process for me. I have to fly to Austin or Houston, then catch the flight to Harlingen, and then drive, and then coming back. If I have to wait on my opposing counsel who lives in Hidalgo County and can drive to the courthouse in 15 minutes to agree that I can appear by virtually, and instead they want to impose that cost on me, then there's no incentive on them to agree for me to be able to do that. And so I think that's where the problem comes in to Rusty's thing about the idea that they're not going to impose costs on themselves. Sure, they're not. But if they can make the out-of-town lawyer have a hard time getting there for a 30-minute hearing, and the judge has no ability to say, listen, we're going to do this one remote, that's the problem. So I do think the judge has got to have some discretion, but I also agree we've got to figure out, I think the biggest hang up is how do we cabin that discretion, and what can this committee, if anything, do to kind of try to lay out some guidelines for deciding how the court can exercise the discretion on that. But if we say we're going to leave it to the parties, it's going to turn into gamesmanship faster than, I don't know, just fast.
Yeah. John?
I think the judge, as the arbitrary or the referee of court proceedings, should be the one who makes that determination. But I think based on what Rich Phillips just said, and I think he should, Judge Miskell, and I think he should be part of the committee as it relates to how we actually fold or create this the process or the criteria for virtual proceedings. But I think that's it. We just have to establish that criteria, and the judge actually just make sure that that's what's enforced.
Yeah. Judge Mendoza?
So I've said repeatedly that I really think that these decisions, and Judge Miskell says too, that the judge has always had the ability to do it. I really think the decision should be remain with the judge. That being said, so having said all that, remember all that stuff I said before. One of the things that I've seen trial judges do, which has bothered me, and I've tried to address with my colleagues, I've had colleagues in El Paso that say, if you're in Dallas and you want to practice in El Paso, you're going to come in for that hearing. And they've made lawyer. This was pre-pandemic. And I'd say that's ridiculous. Why would you make them do that for a pre-trial, for whatever? So when we address the rules and the good cause, we've also got to address that situation. I really think most judges don't do that, but we do need to protect the litigants when you have these. El Paso's not rural, but it's way out here, and you do have some trial judges that have those opinions, and we've had some grievances because trial judges have refused to grant continuances when people are not permitted to fly, for example. So we need to address those things in those good cause provisions as well.
Yeah. Judge Evans?
I think, Justice Christopher, that it's factors that need to be considered, maybe as opposed to specific situations, and how you articulate the factors that would lead up to specific situations. While I was still on the bench, we had a witness that they wanted to bring remotely, and I didn't allow it until they had been able to get a deposition that was satisfactory, in-person deposition, before allowing the witness to appear remotely so that the opposition could do it. Now, this person was out of state, and then we had a cost issue that we had to be assessed, but there's going to be convenience issues, health issues. Has there been discovery that's been taken? And then when you get to, and I'm just talking about a remote witness as opposed to a remote, everybody's remote. But that's where I thought that language that you had put in the rule about any standards adopted by the court I wasn't sure if you would write it into the rule or you would write it into a separate set of standards and guidelines. But it needs something, and it needs something to take up care of Mr. Phillips' issue. It's just, and what Judge Mendoza just said, I mean, there's just no sense in dragging somebody to Fort Worth just because you got the authority to do so over a status, what is simply a motion for summary judgment. Now I digress, where somebody's just going to regurgitate what they wrote and what you have to read and what you have to read and rule on. I mean, that just doesn't make sense. Sorry. Okay.
No.
That's
good.
Cowtown, David. That's Fort Worth, David Evans, and I'll mute myself. Bye.
Somebody invited Quentin Smith to speak here today.
Oh.
Quentin is a partner at Vincent Elkins. And Quentin, I don't know if you know who invited you, but I can't believe they made you sit through this beatdown. And if you got something to speak about, you have earned it, let me tell you. So fire away if you got anything to say about this topic or anything, really.
Chip, Quentin was the subcommittee chair on the subpoena issue. And I told him to come on about noon so that he could present the subpoena issue. But we're not ready to present the subpoena issue.
So you're the culprit.
I don't think. It's
No,
my
we're
fault.
not ready. We're
It's
not
my
ready to get
fault,
to the
and
subpoena.
I would hate to put Quentin in the hot seat at this point in time.
Yeah, we got an angry crowd here, don't we? Quentin, as the chair of this committee, I will extend my personal apologies to you for this beatdown. Although, frankly, maybe it's just because I'm a geek. I found this extraordinarily interesting, and I think it's a very, very important topic for our state and for our justice system. So I don't think it's a waste of time at all. But I think we've talked it out for today. And I think we can come back next meeting and get more into the specifics, including, Kenan, whether we're going to take jury trials off the table. And then, if we get rid of that issue, then we can inform ourselves with that not a part of the discussion. And I'm disappointed that we did not get to talk about the problem with existing local rules approval process. But Kenan, were you going to present on that, or was Nina?
I think that Justice Boyce is going to present, although I would be happy to chime in and take the lead if need be at any point.
Okay.
And I too am disappointed that we're not talking about local rules today. Share that.
Well, I knew that. I know you're probably going to go out and start drinking immediately because of that. But Bill, I apologize to the extent you had to prepare for that and we didn't get to it. We usually
perfectly fine. Thank you.
You bet.
He really wishes he could talk more today, but
yeah, right. Well, I don't know what else to do today other than to say the motion to drink is granted. So we can all go about our business. And Shiva, where are you? Are you around?
Yeah, I'm here.
Where is our next meeting and when is it?
It's in San Antonio. St. Mary's College is going to host us, and it's set for March 25th.
Okay, and we're going to do it in person, and there's no discretion about remote on that, even though Judge Miskell would love to grant the remote motion. We're not going to let her.
Hey, Chip, can I ask everybody to look at the picture of Shiva and the look on her face, which shows to me what she really thinks of this entire proceeding. So I think she's recognized all the different realities of the afternoon. Anyway.
Yeah, that says it all, doesn't it, Rusty?
It really does.
and Quentin, sorry to make you sit through all this, but thanks for.
No problem at all. I enjoyed it. I just wish I would have brought my popcorn.
Yeah, right. All right, guys. Well, we will see you in March, and thanks for everything. I thought it was a terrific discussion, and we didn't attack Lisa as much as we should have, but we got time for that.
There's always March. There's always March.
There's always March. There's always next time. And Chief, are you in El Paso by any chance? You're on mute.
No.
Did anybody get to El Paso?
Well, Tom tried to shame me into going, but the weather's just so bad here last night and today that we even had to have argument by Zoom on Thursday because people couldn't get to the courthouse. So,
well, I had a flight.
Cold here too. Yeah, it's cold here too. You don't want to be here either.
Yeah. Yeah. Well, my flight got canceled. There's no way I could get there. So, so anyway,
Here
well,
it's
thank you,
13
everybody.
degrees and it's a heat wave compared to yesterday.
Right. Right. Well, thanks, everybody. We'll